Good morning and good afternoon to everyone. Thank you for joining me to today's program called 2025 Florida Legal Marketing, What You Need to Know. We have an amazing guest today. And so before we get started, I just want to go over some house rules here and kind of recap who this is for. So today's program is namely, again, for attorneys, marketing, operations staff, and any staff that's in-house or even consultants that work in marketing and ops for you. Today's program is really about marketing, so I would highly recommend sharing today's link and the replay links with anyone that works in within your marketing goals. This is also made for anyone who needs a Florida State Bar refresher regarding marketing. So today's guest is Jonathan Grabb. He works intimately with marketing rules in the State Bar. We'll get into that in a moment, but this is also great for attorneys outside of Florida. It'll give you an ethical perspective on what Florida is doing. There's some overlap with other states in terms of what Florida requires from attorneys in their advertising. So this is really great for anyone that's curious about what's going on in the landscape here. Now, our two promises are as such. Number one, no sales pitches. This isn't about avocados now. This is about providing value to attorneys. These rules are oftentimes a moving target, at least as it's assumed by many attorneys. So this is really about education. This isn't about us. And our other promise is that you're going to have takeaways to implement today. And the only thing that we will cover regards to avocados now is just a brief introduction on who we are, just in case you're not too familiar with us. So Avocados Now is a team of 50 plus across the Americas. You can see some friendly faces on the screen there. We were the first Hispanic marketing agency for attorneys, started in 2017. And we have over 300 firms in our program, over 10 different practice areas. We've been featured everywhere: Bloomberg Law, Lawyerist. We're at conferences all the time, virtual, in person. We're on podcasts quite regularly. And we like to speak a lot about the opportunity in Hispanic legal marketing. That's with website designs and videos and ads and social media. And we're happy to discuss this further offline. But ultimately, the goal is to get you more signups and tell you directly from which your results are coming from. So some show notes. There will be no replay, so take notes. And lastly, if you do want to be in touch with me regarding our programs, just email me directly, hugo@avogadosnow.com. We'll schedule a call if it's appropriate based on your goals, and then get a little deeper into what we can do for your firm, and maybe just give you some free advice. I mean, we're happy to do so. Now, our guest today is Jonathan Grabb, and I want to pull up his bio here. And Jonathan Grabb was promoted to the director of the Ethics and Advertising Department. He's also known as the Ethics Counsel for the Florida State Bar, or the Florida Bar, in November 2021 after 8 years of service in the department. Jonathan has fielded more than 20,000 calls on the ethics hotline, reviewed thousands of lawyer advertisements, and issued dozens of staff opinions. Jonathan is also the staff liaison to the Florida Bar's Board Review Committee on Professional Ethics, the Professional Ethics Committee, and the Standing Committee on Advertising. His work as ethics counsel has included a variety of CLE presentations and bar news articles, including a March 2023 article entitled "Lawyers and AI: How Lawyers' Use of Artificial Intelligence Could Implicate the Rules of Professional Conduct." So we're really super happy to have Jonathan here. Jonathan, welcome to today's program.
Thank you so much, Hugo. It's definitely an honor to be here. I really appreciate you having me.
Yeah, for sure. So lots to get through, but I just want to go through some general high-level items with regards to what I talk to Florida attorneys all the time, and work comp and PI, employment, immigration, and they generally have a lot of these concerns about how to submit their ads for approval. At the highest level, can you explain what that means, especially for attorneys that probably aren't even privy to that role?
Right. So Florida is a state that actually requires lawyers to file advertisements for review with the Florida Bar. And they're supposed to be filed pursuant to Rule 4-7.19 of the rules regulating the Florida Bar 20 days in advance of the intended use. And there is a filing fee. of $150 per advertisement. And that's going to be for any advertisements, basically anything where you're promoting your legal services, your law firm, you're providing contact information for you and how to get your services as a lawyer. Anything like that is going to be considered advertising and must be filed for review if it doesn't fall into one of these specific exemptions that's addressed in another rule, 4-7.20. The primary exemption, the first that's listed there, is that if you only have what is often referred to as tombstone content or presumptively valid content that's described in 4-7.16, this is stuff like your name, your website, your telephone number, your years of experience as a lawyer, when you were admitted to the bar, board certification, very specific images and illustrations like a picture of the Statue of Liberty, the American flag, courthouse columns, yourself in front of a plain background. So it's those very specific pieces of information and others areas of practice that you can have in an advertisement. And if you limit it to only that which is described in that rule, then you don't have to file it for review no matter how you're using the advertisement, whether it's on the internet or in magazines or newspapers or on TV or however. Now, I will say it's rare that you're going to have that for like a TV ad or radio ad because, people like background music and that sort of thing, and that's not exempt. Another thing that often makes something non-exempt content is going to be if you have, again, one of those illustrations that's not specifically listed, or if you have a tagline. So if you're wanting to include a tagline in your advertisement, that we're your hometown lawyers. Well, that's not under the exempt content. So yes, if you're going to include that in your advertisements and it's not under one of the other exemptions in the rule, then you're going to need to file that for review here in Florida if you're going to be using it to advertise to Florida residents or regarding Florida matters.
Got it. I mean, so there's a lot of layers there. There's clearly exemptions to each rule, right? So at the highest level, if someone is running, whether or not they're running, let's just call it a Facebook ad or something very omni-channel where they have out of home and TV and radio, I mean, what's the best, most responsible way to get counsel to submit to the state bar?
So we do have a lot of resources on our website. If you go to floridabar.org, and then at the very top of our website, there's a link for rules, ethics, and professionalism, and then ethics and advertising on the next page. And you can get to our advertising page from that, and it'll give you cover sheets that'll describe the filing process. They'll actually give you a form that provides all of the information that we would need to review an advertisement, as well as it'll tell you where to send it, how to calculate the filing fee, all of that. So that's sort of the generic process. Now, I will say, I'm sure that there are lawyers out there right now who are hearing this and are stressing, I never filed my website. I never filed my social media profiles and posts. Yeah. Well, you only need to file, you don't need to file your website ever. That's actually specifically exempt. And you only need to file those social media posts if they're sponsored or boosted or promoted posts. Same with video sharing. So you can have your own video sharing channel on YouTube, and you don't have to file all that unless you're starting to do those promoted posts where people are going to be seeing it as an ad, when they haven't specifically searched it out.
That's great. Okay, so the good news is that there are resources. State Bar has put them all online, and if you need to see counsel, there's probably folks out there that can certainly help you out. A question I get a lot on the digital side is about AI. Namely, Google has this ad product called Performance Max, where I can enter in, some bio information about an attorney, a few information points about their services, and contact information, right? It'll be like a submission box, and Google will create thousands of iterations of ads based on those inputs. And the thousands of iterations of those ads are meant for AI testing or automated testing. How do you respond to attorneys who wonder if they need to be submitting thousands of iterations of ads for approvals in advance?
Yeah, and we often get filings where it's, 50, 100 or more ads all in one filing.
Yeah.
So we do get that. But really what I would recommend when lawyers are looking at those products, another similar issue we run into is with Google AdWords, where you have multiple headlines and multiple descriptions that are all
Right.
going to be mixed and matched into, hundreds or even thousands of different combinations.
Right.
And lawyers, try and submit these to us without really specifying, individual combinations that they actually plan to use. And unfortunately, our rules have not quite caught up to that yet. Each one of those combinations is actually going to be a separate advertisement and separate ad file under the rules as they currently exist. Now, is that going to be the case indefinitely into the future? I don't know. We'd have to get something from the Board of Governors, as a rule change to be able to address that. But as of right now, if you're using those Google AdWords and they include non-exempt content, then technically each one of those combinations is a separate ad. And so what I would recommend to those lawyers who are thinking about, hey, I'm going to use these AI generated advertisements, and, yes, you could get thousands of different combinations, not just again with the Google AdWords, but with some of this new technology that's generating advertisements for you. Really, you need to go through and sort out, okay, what are the ones that I actually want to use and that are worth my time and effort to file with the Florida bar, and frankly are worth that investment, because yes, it is currently $150 per advertisement. And if you're talking about, hundreds of ads, many of which you may not actually end up using, well, certainly I wouldn't want to drop $150 on all of those advertisements just for the possibility of using them at some point in the future.
I mean, not holding you to this, however, magic wand, if you did address some of these changes with, scaled advertising, what would that look like? Again, not saying that Florida is going to do this, but what kind of vision do you see for the Florida State Bar to address the reality? I mean, and I say that's the reality because it's so competitive. So every attorney that wants to gain incremental market share, they need to gain some competitive advantage. And this is a conversation that happens a lot. So has there been any thought process about like what that looks like, or do you just have your personal opinions on what that looks like?
So frankly, I hate to say it, but my opinions don't matter too much at this point, because it's a policy decision that is beyond my authority to really implement or change on my own. Now that being said, I think that's it's something that, yes, the Board of Governors and the Standing Committee on Advertising, I mean, they're aware of these issues, and it is something that, yeah, we're going to have to adjust. And yes, rule changes can take time, but that doesn't mean that it's, not something that they're trying to stay aware of and, make sure that we're adequately adjusting for the realities of the marketplace. So again, it's far be it for me to try and predict what, the future will bring when it comes to advertisement filing and how to handle those. But as of right now, we're just not quite there yet.
All right, that's cool. I mean, you coming here is enough of a sign to see that like there is a conversation happening, and that I think is reassuring to a lot of attorneys that I speak to, that they just want to know that the governing agencies are thinking about it. So I think that's pretty awesome. Now, I kind of want to pivot just a little bit towards something that's specific to what we do, which is we're in Spanish marketing. Florida uniquely is one of the top 10 states in the country that has hugely densely Hispanic populations, that, many who speak only English, many like myself who speak English and Spanish, and many who only speak Spanish. And so I'm just curious, like, what are the considerations attorneys need to take if they want to advertise in Spanish or other communities in different languages? Like, how do the rules change? How does representation change in terms of whether or not an attorney should be practicing to speak another language, or whether or not they should put, representative voice? Like, what are the considerations that you find are most important when trying to explore other language marketing opportunities?
So yeah, again, We're on the regulation side, so it's tough for me to say what is the ideal marketing offerings or way to approach a certain market. But that said, yeah, I mean, that's certainly something that is big in Florida. And so, yes, we frequently have advertisements not only in Spanish but in Creole, in a variety of languages. We get advertisements in Russian. So yeah, it's very common that we have those advertisements in other languages. I will say, because of the limited staff offerings that we have in our department, we do still require that we would have an English translation for those languages that are used other than English. But beyond that, it's really about the same process. So if you're going to have an advertisement in Spanish or Portuguese or French or Creole, and English, yes, each version, because there's always going to be some things that are different in that translation process, things that may not translate quite directly or in the literal way, yes, each of those is going to be, again, a separate advertisement when we're talking about the review. But really, the process for the review is effectively the same. We are going to go through that advertisement as staff, line by line, word by word, and do the best that we can to make sure that the content, when we're looking at it, complies with what we believe the rules require. Again, those prohibitions on things like, and we haven't gotten too much into this yet, but the common issues that you see lawyers running into, improper predictions or guarantees of results, improper statements of quality or comparisons, improper testimonials from clients. All of that is really going to be the same, whether you're talking about, again, English, Spanish, Portuguese, Creole, or whatever else.
Yeah, that's great. So, but at the highest level, if someone wants to explore other languages, no matter what's submitted for review, that $150 per ad, it needs to come with a corresponding translation of that ad. That seems to be like the process. Okay, great, awesome. Now, so I'm curious, because we did title this 2025 marketing rules in Florida. Like, what are the changes that you're anticipating, or what are the trends that you're seeing in the next year with regards to Florida rules?
So yeah, I don't know that we have a whole lot of specifics that are currently in the hopper for immediately pending changes, beyond a couple of items. Now, I will say, just as a general trend, the advertising rules are getting more and more, liberal, so to speak, over time. That, it used to be 20, 30 years ago that very little advertising was permitted for lawyers. And now we've, clearly expanded that and loosened those restrictions to a significant degree. So really the focus is going to be, again, on, preventing content that is false or misleading for prospective clients. Now, as far as actual trends right now that we're seeing in the rules, there is a rule proposal that potentially would adjust that fee amount per advertisement, as well as the late fee amount. So if you're filing an advertisement, again, timely, 20 days or more in advance of the intended use, then it's $150 per advertisement. If you're filing later than that 20 days or after you've already used the ad, not only are you responsible for the content of the advertisement, if there's something that would run afoul of the rules, but also you would need to pay a late fee of totaling $250 to have that advertisement reviewed after that point. Now, those fees, again, based on a rule change, potentially may change, and the bar may have a bit more flexibility, because those fee amounts haven't changed, and I think it's been about 15 or so years. From that 150 and 250. And so basically right now, our program is actually not fully covering its own budget. And that was really the intent of those fees, is to make sure that they're covering the cost of this review program and the enforcement of the rules. So it's likely that those are probably going to increase depending on what we get back from the Florida Supreme Court regarding that proposed rule change. Another change that is pending before the court, if I remember correctly right now, is exempting legal aid organizations from the filing requirement. Because right now we don't have a clear exemption for their advertisements. But if you're really doing the practice of law to provide services to those who are, really getting pro bono, that it's actually are promoting services that are free legal aid services, that we realize it doesn't make sense to charge an organization that's, trying to provide free services for, filing its advertisements and make them go through that process.
Okay, that's great. So, and when do you anticipate the fee changes to be announced? Assuming that they do go through.
That's really up to the court. And so it's whenever the court decides that they're going to take a look at that issue and then, either potentially adopt or reject that rule. If they do adopt the rule proposal, then yes, it would also then take a little bit further action from the board to consider a change to the rules and then consider a change to the fee amounts and then, publish that and give 30 days notice of that intended change if they adopt the language as presented.
Cool. Thank you. So I'm going to go macro here just because we are limited on time. I could talk to you for 5 hours plus about this stuff, but, we have a little bit amount of time. But if anyone wants to speak to Jonathan, we'll have that information shortly at the end of the program, or the Florida State Bar about marketing and ethics, etc. But at the macro level, when you talk to attorneys or when you're reviewing ads or these kind of considerations or applications, like what are the most common issues and mistakes you're seeing attorneys make? They're spending, several hundreds, if not thousands of dollars for approvals. And you go back to them and say, hey, you didn't even go through the course. Like, what's going on here? So what do you find are the most common issues?
So, really, one of the most common is that they don't file it for review. They don't, in some instances, don't even realize that in Florida they need to file certain advertisements for review with the bar. Because again, that's not entirely unique to Florida, but it isn't the case in all other states. And so, yes, right. That is one of the first mistakes that some lawyers make, is not realizing they have to file for review. Other common mistakes that we really frequently see are going to be, again, those predictions or guarantees of results. I will get you those Social Security benefits. I will get you a settlement in your personal injury case. Money for you, within, just one phone call is, your check is a phone call away, sort of thing. Those statements, again, those are improper predictions. You won't have to appear in court for your offense or your potential charges. Again, those are things that, even though they're not necessarily a result at the culmination of a matter, that's still, something that would require a legal process and that you can't absolutely guarantee, because there may be some instances where, yeah, this person will have to appear in court in those circumstances. I'll save your home from foreclosure. So again, these are all things that, yes, would be improper predictions or guarantees. Now, the easy way around that in most instances is to say, make it aspirational. Say, I will fight to save your home. I am dedicated to getting you the benefits you're entitled to. I will work to get you the recovery you deserve, which that's actually one of the sort of catches, is that they've treated that as aspirational, that, okay, you may deserve nothing. It may be the settlement you deserve is zero. But, yes, as long as you have those terms to make it aspirational, so it's not an actual prediction or guarantee of specific results, that is an issue that can be avoided. Other common issues, as we noted earlier, include improper comparisons or statements of quality that are not objectively verifiable. And so what that really means is, if you're going to say that you're the largest law firm in the state of Florida or in the United States, which we have some ads in Florida that claim that, you need to be ready to objectively verify that. That if somebody files a complaint about you as a lawyer or your law firm making those statements in the advertisement, you actually need to have some way to prove, to establish that you are in fact the largest law firm in the United States or in Florida. So again, these are statements that you need to have as objectively verifiable, something you think you can prove. Now, there are certain statements that the committees have said are not objectively verifiable no matter what you do. You can't say, I'm the best. I am uniquely qualified. So yeah, those lawyers who say, I am uniquely qualified to be your criminal defense attorney because I used to work in the prosecutor's office. Well, so did, hundreds or even thousands of other lawyers in the state of Florida who went from the prosecutor's office to now practicing criminal defense on a private basis you are not that unique. I'm sorry to say. I know it's disappointing and hard to hear sometimes, but yes, there are many other lawyers who have similar qualifications. So again, those are statements that we've said, you cannot objectively verify, because again, sorry, no, you can't say that you're the best. You can't say that you're completely unique in your qualifications. So yeah, those are those statements, and they're focused again on the legal services. To say we pride ourselves on great customer service, that's a bit of a different thing than saying we pride ourselves on great legal services, or our legal services are impeccable, or are top tier, or whatever you may want to say. Again, those are statements of quality and even potential comparisons in some instances as well. That, yes, unless somehow you can objectively verify that, that's going to be a problem under the rules. Another one of the things that we mentioned earlier, testimonials. There are very specific requirements for testimonials in the state of Florida. You can't have an actor who's giving the testimonial in the person's place. You have to have the person's informed consent to use their testimonial, and yet you also can't give them anything of value in exchange for the testimonial, and you can't write it for them. So you can't tell them, hey, this is what I want you to say on camera. And then, you hear them, sort of reading it, my lawyer is the best lawyer. No other lawyer could have gotten me these services. And it, again, has to also be something that they're actually qualified to evaluate. Unless they somehow know what every other lawyer is capable of, they can't say, my lawyer is the only lawyer who could have accomplished this. So they can say, I had a great experience, as a testimonial. Again, if that's their words and that they're coming up with it, they can say that they were extremely happy with the results, but you can't write that for them to say, and you can, again, can't give anything of value in exchange for them giving that testimonial. You can't go on Google reviews and pick your favorite reviews and have an actor read them off. Again, it has to be that person's actual experience. And if you're going to go on Google reviews and use those in your advertisements, you need to make sure you get the person's informed consent, because that is information about the representation. Right. And when they made that Google review, they may not have anticipated it being published more broadly. They may not have wanted their family, or their friends, or relatives that suddenly show up out of the woodwork to know that they just got, a $2.2 million recovery in their case, because unfortunately that is part of what happens sometimes.
That's great. And so it sounds like if you were to distill it, it's tell the truth, whatever you share, make sure it's objectively verifiable. And if you bring anyone else in, let them speak their truth to their experience with you.
Absolutely. Yeah. That's a very succinct and great way to put it.
And it's like you just got to use a lot of common sense here, but it's easy to get carried away. And I've seen it with plenty of attorneys in our experience who just want to move fast and just kind of break things. But I mean, what are the penalties, about not filing accordingly and then getting caught?
So, yeah, I mean, that's unfortunately the penalties can, depending on the severity of the violations, I mean, it could range from anything from, okay, you just need to pay the late filing fee, and then, we're going to call it a day for this one. If it's a first time violation and there's nothing really that substantive in the ad itself that would be a problem or a major concern, all the way up to, if you're directly soliciting clients, you're the sort of prototypical ambulance chaser, and you're showing up at people's hospital rooms, that can result in disbarment. I mean, so it can go from, just paying the late filing fee, having a diversionary program, to public admonishment or public reprimand, to a suspension. And then, if you're really, doing things improperly, it's the gamut of potential sanctions. You could be disbarred if you're really engaging in egregious and continued conduct.
So what do you recommend? Because most attorneys that we work with don't have the time to, they should all go through a CLE. I would imagine that there's probably a CLE for marketing in Florida. But I'm just curious, what do you recommend attorneys do if they're looking for the right vendors, the right marketing partners, who are going to get them down the right path, as opposed to being super improvisatory and, fairly risky?
Yeah. So of course, make sure that you have a vendor, a marketer who is familiar, not just with advertising in Florida or advertising for legal services, but specifically who is familiar with advertising for legal services in Florida. Because again, our advertising rules are more complicated and frankly more restrictive than many other states. Again, that filing process doesn't apply to every other state. So if you don't have a marketer who really is familiar with that, the risk that you're taking is that you will get in trouble. We don't regulate marketers here at the Florida Bar. So if you use a marketer who doesn't know what they're doing, then that will get you potentially in trouble. Again, as a lawyer, we're not going to try and go after the marketer. We're going to say, lawyer, you should have known what you were doing. You have a duty under the rules to supervise the conduct of your non-lawyer staff and assistants and contractors to make sure that it complies with your ethical duties. So yeah, that is the risk that you'd be taking. Now, how can you do that? Well, frankly, the easiest way would be to ask them what they know about the filing program or what they know about the rules regulating the Florida Bar or our advertising rules. And if they give you a blank stare in response, that's not what you're looking for. You need to keep looking if that's what you get. So yeah, that's really what I would suggest, is that if they can't give you some sort of indication that they are familiar with Florida's advertising rules for lawyers, then yeah, you probably need to find somewhere else. And maybe if you want to be nice, you can point them to, hey, this is the page you really need to look at. Again, that advertising information page on the Florida Bar's website. But yeah, I would not be inclined to trust somebody with my license who did not appreciate the importance of complying with those rules.
Yeah, I would add to that, just have anyone that you're exploring marketing with show proof that you've worked with other attorneys in Florida, show the track record of how you package the advertisements for submission of approval. I mean, there's so many ways to demonstrate that. And yeah, to your point, Jonathan, if they come back with a blank stare, let's move on fast. Because yeah, we like to abide by ABA, and then after that we go a layer deeper per state whenever we work with an attorney, and we have to demonstrate that we understand what they're up against. So oftentimes in Florida, Texas, Louisiana, South Carolina, really similar rules for submission. We understand that we can't launch fast. Like, we certainly could if we break all the rules on behalf of the attorney, but we don't want to do that. We want to do things properly. So, all right. So I'm going to go to the last question here with regards to buying leads. So what is the firm, what is the state bar's position on attorneys buying third-party leads?
So it depends on what you mean when you say buying leads. So this term is used for a variety, frankly, of actions that we've heard. If it's simply buying information, hey, we have this database, we've gone through public records, these are individuals that have made claims for Social Security benefits and they were denied. And so this is the list, lawyer, that we are providing you that potentially we could send out direct mail advertisements to. Those leads are something that, you wouldn't need to be what Florida calls a qualifying provider. You wouldn't have to be a lawyer referral service and go through all the potential processing and reporting for that, if that's the type of leads that you're talking about. Now, for direct mail communications, you do have to say how you got the information. So if your marketing organization is saying, hey, we have these leads for you, it's a trade secret as to how we got the information, so we can't tell you, that might be a problem for you as a lawyer, that you have to be able to tell the person where you got the information, or in the alternative, if it's what we refer to as a targeted mailer or email, you can tell them the scope of your knowledge. So if you just have their name and email address and the potential fact that they were at Camp Lejeune or whatever it may be, again, that's potentially enough information without saying the source of the information, as long as that is all the information that you have. So again, those types of leads aren't really going to change the advertising process a whole lot when you're talking about Florida advertising. Now, when you talk about buying leads in the sense of, hey, this person came to us and now we're referring them to a lawyer, or we're matching them with a lawyer, then that's a different process. And that's when you would, as a non-lawyer organization, have to be what Florida refers to as one of those qualifying providers. And this is addressed in another rule, 4-7.22 of the rules regulating the Florida bar, that encompasses all those different types of services, the referral services, the matching services, all of that, pooled advertising, what have you. And there are certain requirements, again, that apply to those organizations. They have to have at least 4 different lawyers from different law firms. You can't just have, one law firm that you refer everything to as a qualifying provider. So again, you have to have those 4 different organizations. You still have to file your advertisements with the Florida Bar for review, just as if you were a lawyer, unless they fall under one of those exemptions. And also you have to do annual reporting about the lawyers who are participating in your service. As a lawyer, again, that's who we regulate. We don't regulate the qualifying providers, these non-lawyer entities directly. So if you do your due diligence in trying to research a qualifying provider before you start using them, even if they violate the advertising rules, basically the Florida Bar, as provided in the rule, has to give you 30 days notice to cease participation with that qualifying provider before we can take action against you for what the qualifying provider has done. Now, if you go in and you don't do your due diligence, you just have some marketer who shows up at your door and you say, yeah, sounds great. And you don't research them at all. You don't make sure that they're actually trying to comply with the advertising rules. And they start sending you clients and referrals or matching clients with you, then that's going to be a problem. Because again, there you don't get that 30-day safe harbor period because you haven't even tried to make sure that you're complying with the rules. If they violate the rules and say they directly solicit clients, they could get you in trouble too. So yeah, that it depends on what you mean when you say, again, those sort of leads. But
Sure.
On the whole, again, social media, another situation where we have a lot of questions about, well, is this really a targeted ad? If it's just based on demographic information, no, you don't necessarily know that person has an actual legal problem.
Right.
It's just, okay, they're over 65. They potentially, they may have an interest in getting Social Security benefits, or maybe they had some benefits denied. And so that's the pool of individuals we're going after. That we're going to advertise to. That's not a targeted advertisement. Again, it has to be if you actually know that the recipient has a legal problem.
That's fantastic, Jonathan. Wow, that's loaded, man. Thank you. So we're just at time right now. Lily, do you mind putting up the contact card? And Jonathan, while Lily puts up the screen, just curious, what's the best way to get in touch with you?
Sure. Yeah. So the number that you're seeing right now is the best way to get in touch with our office. We have 8 lawyers and several non-lawyer staff who are working in the ethics and advertising department. And we spend, about half our average day on the ethics hotline answering questions over the phone at that number that you see right there, 1-800-235-8619. And so if you're a Florida lawyer and you're looking for advice about your own proposed future conduct, whether that's under the other ethics rules or under the advertising rules, you can call that number and somebody will pick up the phone between 9 and 5 on weekdays. And yes, we'll be able to help you right then and there and try and provide you with advice. That's
amazing, Jonathan. And regarding CLEs or just any type of education that goes a little deeper, I mean, you shared with me a few days ago a PowerPoint where you walk through specific sections of the codes. I'm just curious, like if attorneys want to get a deeper dive, full understanding of the rules here, what's the best course of action for them?
Sure, yeah. The Florida Bar does try and provide as many resources as we can to lawyers who are looking for information and to marketers, frankly. It's accessible to them as well if they're trying to get information about the advertising process or the ethics rules. In particular, for marketing, what I would suggest to Florida Bar members is go to floridabar.org. There's going to be a members drop-down menu, and then go to the Practice Resource Institute, also known as Legal Fuel. And if you go to Legal Fuel's page, they have a tab specifically for marketing that will actually give you a variety of free CLEs, as well as other articles and information for resources that you can look at. And so if you're looking for, you need free, some free CLEs for your CLE reporting cycle, yeah, just go take a look at Legal Fuel. They've got podcasts, they've got videos. And that'll give you some additional guidance about how you can make sure that you're staying on the right side of the advertising rules in your marketing.
Awesome. You guys have tons of resources compared to a lot of other state bars. This is chock full. We've gone through the website quite a bit. So, Jonathan, thank you so much. Please stick around for a sec. And to everyone watching, thank you for joining us. Thank you for watching. Please share this video as much as you'd like with other legal professionals, whether they're attorneys, again, legal marketers, operations folks. We really appreciate it when this is shared. And to the team that put today's event together, JC, Lily, and everyone else, thank you so much and have a great day.
Thank you again for having me.
Thanks, Jonathan.